We're here for an emergency hearing in Levine and Libra Fund versus the Dickey Company LLC. If we could start off with introductions so I know who is here in the courtroom.
Your Honor, this is Chris Peel with the PNT Law Firm, along with our summer intern, Ms. Sammy Harden, who's a soon-to-be senior of Texas Tech, but spending the summer with us, on behalf of Libra Fund and Mr. Jeremy Levine.
Your Honor, this is Thomas Haskins of Barnes & Thornburg on behalf of the Dickey Company, and also with me are my colleagues Curtis Green and Amanda Gallagher. Neither Mr. Green nor Ms. Gallagher are admitted in Texas, but with your Honor's indulgence and given their background and long history in this case that's been ongoing for quite some time, they've appeared and may need to answer some questions. I've just, over the last 6 hours, been involved, so there may be some details that I'm unaware of, but with your Honor's indulgence, I'd like them to be able to speak to those to the extent they arise.
Okay, well, I'm not sure that that's permitted under the rules, but we'll see if there are issues that come up. We'll deal with them as or if and when that occurs.
Understood. Thank you, Your Honor.
Okay. All right. And so, Mr. Peel, it's your application for a TRO. You may proceed.
Yes, Your Honor. It's set forth in our petition, but in short, the Dickey Company and my clients, well, the Libra Company in particular, Libra Fund and the Dickey Company have a contract. That contract does not contain an arbitration provision. There is no contract between Jeremy Levine and the Dickey Company. They had this contract. It was related to a life settlement arrangement where clients of Mr. Dickey, who runs the Dickey Company, were investing in life settlements, which is where people purchase life insurance policies at a discount, and they take the payout when those life policies come due at the death of the insured. In February of this year, Mr. Levine gave written notice on behalf of Libra Fund that he was not going to continue further with the contract. The Dickey Company then almost immediately instituted arbitration proceedings, despite the fact that there is no agreement to arbitrate. Those arbitration proceedings originally were set to take place in Puerto Rico. They're now set to take place in Indianapolis under the AAA rules. Their claim is the Dickey Company's claim. They acknowledge that there's no agreement to arbitrate with Libra Fund or Mr. Levine. Their claim is that they have a separate contract with a separate company named Capstone, which is not owned or controlled by Mr. Levine. There are separate individuals that run that company. And in fact, they've been made defendants in the arbitration as well, as has Capstone. And the Dickey Company claims that because of equitable principles, Mr. Levine and Libra Fund are stopped from asserting that they don't have an agreement to arbitrate, and they are bound to arbitrate, even though there is no contractual agreement. As we pointed out in our original complaint and our motion, application for TRO, the law on this is very clear. Arbitration is a creature of contract. You consent to it by contract or not. Texas Civil Practice and Remedies Code specifically has a provision that says a court may stay an arbitration that's been commenced or threatened on application and showing that there is no agreement to arbitrate. I don't believe that the Dickey Company's counsel today will assert that there is in fact an agreement to arbitrate between their client and my clients. I think they're going to talk about these equitable principles, which I'll get to in a second. But we are asking that you sign off on the requested temporary restraining order, which would enjoin them from continuing this arbitration against Libra Fund and Mr. Levine. We've never agreed to do it, certainly never agreed to do it in Indianapolis. Further, the contract at issue calls for, it's not only an absence of an agreement to arbitrate, which would be plenty for you to sign the TRO, but the contract that does exist between Libra Fund and the Dickey Company specifically states that any disputes arising out of it will be litigated here in the Travis County courts. So there's actually an affirmative agreement between these two parties as to exactly where and how they will settle their disputes, and it's in the courts of Travis County applying Texas law. I will speak very quickly to what I anticipate will be at least what has been the response of the Dickey Company in the arbitration. I just want to quickly give a history there. The arbitration was instituted in late January. We immediately let the AAA know that we don't have an agreement to arbitrate with these parties and thought that we should not be in the arbitration. The first response from the AAA was, well, wait till an arbitrator is assigned. We're just the AAA staff. We don't make these decisions. So we waited until an arbitrator was assigned. That took a little bit of time. There was a dispute that we did not partake in as to whether the arbitration would take place in San Juan, Puerto Rico, or Indianapolis. It was eventually decided by the AAA that would be Indianapolis. All the while, we continued to raise our hand and say we shouldn't be here. AAA has no jurisdiction. We don't agree with this. Once the arbitrator was selected, a commercial litigator in the Indianapolis area, we had a status conference, and we once again reasserted status conference that we don't have an agreement to arbitrate and should not be here. We need to be dismissed from this arbitration. She asked us to put that in writing, so we filed an objection to the arbitration in the arbitration saying we don't have an agreement to be here. The Dickey company filed a response saying, well, that's right, you don't have an agreement to be here, but you're equitably stopped from saying that, from maintaining that position. You're going to have to arbitrate with us. And the arbitrator's response was to say, well, let's have an evidentiary hearing about this. And I guess it was yesterday, we received a communication from AAA, and this is one of the exhibits to our lawsuit that we filed, saying that evidentiary hearing is now set for August 15th. So my clients are now faced with a situation that there is an arbitration they never agreed to be a part of in Indianapolis, where they never agreed to settle disputes, apparently attempting to apply Indiana law, because that's what the Dickey company is citing in all of their responses to our position. And if we don't show up and don't participate, I have no idea what the arbitrator will do, but we're not going to participate any further. And we are being deprived of what exactly our clients negotiated for, which is settlement, disputes to be resolved here in Travis County, in the courts of Travis County. And I want to speak lastly to the points for a TRO. We have a clear right to relief. The CPR, Texas Civil Practice Remedies Code, gives us a very specific provision for these circumstances that says we can apply for a stay if we haven't agreed to arbitrate. We will suffer irreparable harm because our client is faced with the Hobson's choice of either participating in arbitration they never wanted to be a part of and have never agreed to be a part of, so kind of being strong-armed into it to try and protect their interests so that some ruling or award doesn't come out of that arbitration against Levine and Libra Fund, or they, if they don't participate, then they are stuck with losing the right to have it heard in the court of their choosing under the rule of Texas law, and have a jury trial if it comes to that. There is no adequate remedy that can undo that. There's no amount of money that can say, well, here's what it costs. Here's the difference between having your case decided in this forum versus that forum. The likelihood of success on the merits seems very strong in favor of Libra and Levine. It's undisputed that they never agreed to any arbitration with the Dickey company. 5 is the balance of hardships. This supports granting the TRO. We're not asking you to enjoin the Dickey company from bringing claims against Levine and Libra Fund. We're only asking you to enjoin them from making them participants in an arbitration they never agreed to. If the Dickey company believes that they have legal claims under Texas law and that can be rightfully filed here in the Travis County District Courts, they can. Obviously, we're not asking to enjoin them from that, but that's what they agreed to when they signed the contract. And finally, speaking as to the issue of bond, obviously, the courts will normally impose a bond as a precondition of the TRO taking effect. We would respectfully submit that the bond in this matter should be set very low. We're suggesting $1,000. The Dickey company is not precluded from protecting their rights as they see fit in the Travis County courts. It's just preventing us from being dragged across the country to an arbitration we did not agree to. And with that, I will note that the Dickey company has these equitable arguments as to why they think they should be able to keep Libra Fund and Levine in the arbitration. I will just, rather than getting into the weeds of all of them, I'll say a couple things. First, if you read all of the case law that they cite, they're actually coming at it backwards. All of these equitable principles are for the situation where you have a non-signatory plaintiff, that would be the Dickey company, didn't have an agreement to arbitrate, and you have a signatory defendant, that would be my clients did have an agreement to arbitrate, or were working in close conjunction with someone that did. And these cases are all about defendants compelling arbitration, which is a situation you've probably seen many times in your courtroom. Somebody starts a court case and the defendant runs in and says, "Judge, stay the case and compel us to arbitration. We've got an arbitration agreement." Or a variation of it is that plaintiff is suing us based upon the contract that has an arbitration agreement, but they're trying to avoid it by maybe naming our CEO as the defendant instead of naming the company. There's all sorts of gamesmanship that goes on there. So there is a body of case law that addresses those situations, but it's always the reverse of what we have here. There is no case law, and none that I've seen cited by the Dickey Company, that says a signatory to contract number, plaintiff signatory to the contract that has an arbitration agreement, contract number 1, can also sue defendant number 2 and force them into arbitration, even though they have an express contract between them that says nothing about arbitration and in fact says affirmatively it needs to be litigated in the courts. So that I'll stop and either let my colleagues speak to the point, or if you have questions for me, I'm happy to answer them.
No, I think we'll hear from Mr. Haskins.
Thank you, Your Honor. Two procedural matters first that should actually dispose of this relatively quickly. The first is that one of the things that counsel left out in the recitation of the timeline was that there was no effort to comply with Travis County Local Rule 2.2. In fact, despite counsel knowing that the Dickey Company is represented by, among others, Mr. Green, Ms. Gallagher, and several other lawyers at our firm, and have been for the last 6 months, there was no effort to confer with respect to either setting this hearing. There was no indication that a TRO was going to be filed. And it was not until after Mr. Peel and his colleagues spoke with the court coordinator yesterday afternoon, in fact, several hours after that conversation, that any notice was provided whatsoever to Mr. Green or Ms. Gallagher or any other attorneys for the Dickey Company that this matter would be set. That, in part, is why, unfortunately, you're having to hear from me, who has not been involved in this matter. Certainly, had anyone from Libra Fund reached out, we could have, one, determined if this could be resolved short of the necessity of a TRO filing, and at a minimum, two, explained, hey, if we want this fully in front of the court so that she has all the facts and law that's relevant, then we need to set this at a time that is actually mutually agreeable for all of the parties. For that reason alone, the rest of this hearing should be stricken and pushed off. Second, the CPLR section that the plaintiffs cite in urging that this court has the authority to stay the arbitration is also the exact reason that venue in this court to stay the arbitration is not appropriate. CPLR 171096. Excuse me, let me make sure I got that.
All right,
right.
Counsel, I don't know what you're referring to.
That's what I'm about to read for you, Your Honor. So,
what does CPLR stand for?
Oh, sorry, Civil Practice and Remedies Code, CPRC. Sorry, I didn't know. I was in New York recently, and it's CPLR there. CPRC, CPRC 171096 says very explicitly that if a hearing has occurred in an arbitration before an initial application like the ones filed by plaintiff is made, then that application must be filed in the county where that hearing took place. Here, that is undisputedly Indianapolis, Indiana. The Texas Supreme Court in 2012 affirmed that this is a mandatory venue provision. So, had plaintiffs wanted a Travis County court to opine on whether or not the arbitration should have been stayed, then the time to have made that application was in the months between when the arbitration was filed and when a first hearing was held in the arbitration. They never did, because they waited until after a hearing had occurred in the arbitration. The CPRC 171096 kicked in, and at that point, they were required to file any application like this one in the county where that hearing was held. That was Indianapolis, Indiana. That alone means this is not the appropriate court for this application. Moving to the merits, there's a little bit of a confusion on the timeline. Plaintiffs' counsel started off by saying that they had sent a letter in February terminating their relationship with the Dickey Company, and it was immediately after that that an arbitration was filed. Well, obviously that's not right. Concedes later the arbitration was filed in January. The arbitration is actually against the Libra Fund, as well as another entity called Capstone and related entities, who are currently embroiled in a significant FBI investigation for having stolen nearly $8 million from investors, including our clients. The Libra Fund were their agent, which is why they have been named in the arbitration. Contrary to what plaintiffs' counsel represented, there's significant case law suggesting and stating outright that a non-signatory to an arbitration provision can be compelled to arbitrate under a multitude of scenarios, one of which is if they accept benefits under the contract that has the arbitration provision. If they're an agent, such as exists here, if there are equitable principles that would require them to arbitrate, such as we state exist here. In fact, the escrow agreement that the plaintiffs rely upon to say there's no arbitration agreement, even if that agreement didn't exist, the Dickey company still would have named the plaintiffs in the arbitration. That agreement is not required for them to have been named in the arbitration. They would have in any event. Second, there's no fire here, right? A TRO is an extraordinary remedy. The plaintiffs need to come in here and tell you that it's not only irreparable harm, it's immediate. And if you don't act right now, before the parties have an opportunity to be fully heard on this issue, that there will be irreparable damage. This arbitration was filed in January. The plaintiffs do a pretty good job in their pleading detailing the many times at which they have gone to the AAA and said, we don't think you have jurisdiction, we're going to contest jurisdiction. Every time they filed something with the AAA about jurisdiction, they were affirmatively choosing not to file something in Travis County to contest jurisdiction. So why it is that 6 months have passed and all of a sudden it's a fire drill is not explained. They could have made this application 6 months ago, 5 months ago, 4 months ago, 3 months ago. They never did. That's cost them venue. And two, it's cost them credibility for them to say that there's now all of a sudden an urgency. To that same point, August 15th is not an evidentiary hearing. August 15th is a status conference. There's a placeholder evidentiary hearing for August 30th, but August 15th is not an evidentiary hearing. It's a status conference. In addition, the plaintiffs note a few times that they have objected to the jurisdiction of the arbitrators in the AAA, and that's true. But what's important to note is that they've actually appeared and made clear that they appear in the arbitration for the purpose of contesting jurisdiction. So, for example, in Exhibit C of their petition that they've filed in this matter, you see that they tell the AAA that they are putting in a special notice of appearance for the purpose of contesting arbitrability, i.e., they are telling the AAA, we are going to put the issue of arbitrability in front of you, the AAA. This email was sent on January 31st. You will not see any filing in Travis County on January 31st that they said the issue of arbitrability should be in front of a Travis County court. If you look at Exhibit F, which is an April 11th, 2024 filing that they made with the AAA, they actually criticized the AAA for not having adjudicated the arbitrability issue yet. They say that the AAA had refused to adjudicate the issue. April 11th, if you check the docket, you won't see that they ever try to put that in front of Travis County. They've now fully briefed the issue in front of the AAA. And it's not until now that they say, okay, now we're going to go to Travis County and say, you should actually step in. Whether this is for delay or because they forgot or because they've just decided they need to take as many shots at it as they can, it doesn't change the fact that they have continuously put the issue in front of the AAA. They have decided not to file this for a 6-month period when they're now telling you that you're the only one that can make the decision. That they've done it in a fashion to make it seem as if it's an emergency, but in a way that violates Travis County's local rules and also never provides an opportunity for the Dickey company to fully brief the issue and put in the evidence that we believe shows that they are subject to arbitration. And they did it in a court that's not appropriate, given that venue no longer sits in this court now that a hearing has been held in the arbitration in Indianapolis. I'll also end on one note, which is that plaintiffs' counsel made a suggestion that arbitration isn't appropriate for non-signatories when there's not a close conjunction, was the phrase that he used, between the signatory to the arbitration provision and the party that against whom arbitration's trying to be enforced. That close conjunction, that is exactly what the Dickey company has alleged and believed exists between the Libra funds and Capstone, the other parties to the arbitration and the other arbitration agreements. With that, I will answer any questions that the court may have.
I'm going to hold any questions I might have until after I hear from Mr. Peel. It's your motion, so you get the brief final word with the understanding these are these are short emergency hearings, 20 to 30 minutes, absolute max. And we do have a hearing coming in after you.
Message taken, Your Honor. We'll go in reverse. First off, Mr. Hoskins said that we do not have a hearing on August 15th. If you look at Exhibit H, it says, please take notice that a hearing in the above referenced arbitration will be held as follows, type motion hearing, video conference. I think it's a hearing. It's not a status conference. That's what they've said. He takes issue with the fact that we have not gone to the Travis County courts for relief earlier. We thought sending a letter saying we don't have an agreement to arbitrate would have been appropriate before running to the courts. We've been waiting patiently. When they finally gave us an arbitrator, we gave them a letter that said we don't have an agreement to arbitrate. He says that it's been fully briefed. Our full briefing is entitled Objection to the Arbitration, objection to jurisdiction. It encloses 2 pages with our signature block. It says we don't have an agreement to arbitrate. We've been very specific in our position with the AAA. We're simply saying we don't have an agreement to arbitrate. But to the extent it matters, the Supreme Court has said that it doesn't matter what the AAA rules or what it doesn't rule, what Mr. Hoskins says about us asking them to dismiss us from the arbitration. As the Supreme Court's made clear, quote, arguing the arbitrability issue to an arbitrator does not indicate a clear willingness to arbitrate that issue. They want to have it both ways, just as they want to have it both ways with the contracts. They brought us into the arbitration, and when we point that out to the arbitrator and to them in arbitration, they now say, aha, you're stuck in arbitration, even though you don't have an agreement to do it. And there is an urgency to this. Now that we have this evidentiary hearing scheduled for August 15th, we are put to the choice, either participate in the arbitration that we should never be a part of, or suffer the consequences of not showing up and not defending our interests on behalf of our clients. That is a position we should not be in. You should enter the TRO. If they want to fully brief this up more for a court at a temporary injunction hearing, obviously you'll be setting a date for a TI hearing within the statutory period we're allowed for a TRO to exist. That will give them time to brief it up and put it before the person that in fact is supposed to determine whether or not we have an obligation to arbitrate, and that is a judge. As the Supreme Court has said, arbitration is a matter of consent, not coercion. Parties cannot be compelled to arbitrate any dispute absent an agreement to do so. And that is very clear that the courts decide whether the parties are bound by a given arbitration clause. That first quote was from Robinson v. Homeowners, which is a Texas Supreme Court case, which we cite. And I believe we cite in our motion. If not, I can provide it to the court. And then the other quote about whether the parties are bound by a given arbitration clause decided by courts is from Lupe Holdings, which is a appellate case out of the First District in Houston from 2022. It's clear, Your Honor. And as to the venue that we should have filed this in the court where the motion was first heard, there has not been a hearing on our motion. We filed an objection to the jurisdiction, and the court, in response to the arbitrator, in response to our objection to the jurisdiction of the arbitrator, has now set a hearing. But we have not participated in that hearing, and we don't intend to participate in that hearing. That's why we're here now. So it's a bit of a red herring to say go file it in the county where it happened, which is what they really mean is Indianapolis, which obviously the Texas Arbitration Act and the CPRC doesn't cover that. It's not sending people abroad to go file their request for court relief in the courts of another state. So that I'll stop and answer any questions you have.
Okay. Mr. Peel, you didn't submit a proposed order with your application, so I don't have in front of me what you're asking me to do. Can you share screen with what your proposal is?
I'm happy to do that. Let me bring that up real quick. All right, Your Honor, are you able to see that?
Yes, I can.
Okay. I don't know if you want me to try and summarize it or if you'd prefer to just read through it. I don't know what's quickest for you.
You can just go ahead and scroll to the next page.
Okay. These paragraphs are sort of the findings that I would propose you would make after the hearing, and then.
Okay, well, I'll say right off, this is not an evidentiary hearing, so sure. Not sure that the court's going to be inclined to make findings. But if you could just scroll down.
I'll scroll down to the actual relief requested here.
Okay, that would be helpful.
So we're asking for two things: that the defendant, Dickey Company, be immediately restrained from engaging in arbitration proceedings against the plaintiffs, my clients, in Indiana or elsewhere, other than immediately dismissing them from the arbitration, and that they be restrained from naming my clients as a party in any filings, briefings, motions, or pleadings with arbitrators, whether that's new or some other arbitration down the road. We just don't want to be, we should not be brought into any we shouldn't be in the arbitration we're in, and we shouldn't be brought into any other arbitration. That's obviously covering any attempt to bring an arbitration, say, in Texas or elsewhere. And then we ask, obviously, that you issue notice of the TRO and set this for hearing at temporary injunction hearing sometime within 14 days.
Okay, so typically the purpose of a TRO is to ensure the status quo until a further evidentiary hearing can be taken. Ordering dismissal or restraint from doing things in other in AAA, I don't know. You have authority that is an appropriate basis of relief for a TRO?
Well, Your Honor, if they're not obligated to dismiss us and they continue on with the arbitration, then we've gotten no relief at all. And I think Texas Civil Practice Remedies Code 171.023 says a court may stay an arbitration commenced or threatened on application. Now, in fairness to the Dickey Company, they have named other defendants in that arbitration. They've named Capstone, and they've named 3 individuals associated with Capstone. I think it would be beyond the scope of the relief that we need for you to stay that entire arbitration. I mean, they may have things that they want to accomplish or do or move forward on that arbitration with respect to those other defendants. So that's why I have not proposed relief of asking you to stay the entire arbitration. I think you just need to stay it as to us. Now, I understand your point that the dismissal is maybe a step beyond staying, but if that we can make that amendment to the order, if it says that they are stayed from pursuing any further relief against us, I guess that they could inform the AAA that they've been stayed and that the hearing as to us should be stayed or put off as well.
Your Honor, if I may be heard on that point, you're hitting the exact issue, which is that the status quo right now is that there's an August 15th status conference, and I understand what he's looking at says hearing, but again, Mr. Green or Ms. Gallagher, correct me if I'm wrong here, but it's a status conference. There isn't anything that would be occurring. And actually, the CPRC already contemplates that this type of action, i.e. an action to stay in arbitration, is to be decided summarily by the court, meaning expeditiously, so that exactly what the plaintiffs are asking for here occurs, which is that you are able to ultimately make a determination on whether or not arbitration should be stayed. But there's no need for, in effect, an anti-suit injunction when nothing's going to be occurring over the next couple of weeks. There's no new arbitration that's going to be filed. They've been named in the arbitration they're going to be named in, right? There's no immediate evidentiary hearing that's going to occur. There's no need for a TRO. It's an unnecessary statement by the court that it believes that there's a likelihood of success on the merits and potential irreparable harm. And one of the other threshold issues that the court's going to have to determine is this venue issue. And I know Mr. Peel has said there was no hearing, but I'll read from his petition. Paragraph 21, on May 9th, 2024, the AAA held a hearing. So they've already conceded a hearing was held. So venue's not proper here. But nothing is going to occur. A TRO is an extraordinary remedy, and there's been no showing that an extraordinary remedy is necessary here.
Okay. All right. Mr. Peel, you could bring the screen share down.
Sure.
I'm going to ask that you send a copy of that to the court staff in Word form.
Yes, I will. Do you want me to send that to Ms. Seeger or to your submissions?
Ms. Seeger would be fine. All right. Well, based on what I've heard this afternoon, the court will take a look at the TRO. I think it's likely to be modified from what Mr. Peel proposed, because I think the proposed order does more than maintain the status quo. But I'm going to make some revisions to that order, and you'll get a copy of the order from the court or from the clerk later today, in all likelihood, or if not today, in the morning. Yes,
Your Honor. One point of clarification there: if upon modifying it, the court is inclined to enter the TRO. The issue of bond, we normally have to set a bond. It doesn't become, the TRO won't become effective until a bond is set, and we deposit that bond with the clerk, I believe.
Yes. So if you're sending it to me in Word form, we'll make sure that if it's granted, there will be a bond amount included.
Okay, perfect.
And also, just to correct something you stated earlier, the court does not actually set a hearing. This is state court, so you set your own hearings, and you will need to confer about a further evidentiary hearing on this. And so the court administrator's office is who you need to speak with.
Okay, Your Honor. I'm sorry, I was under the impression that in the TRO, it needed to specify.
Yes, it does. It does need to specify, but you got to talk about that date offline and get it set with the court administrator.
Okay, and then you'd like us to provide that to you to include in the order?
Yep.
Okay, we can do that.
I know it's a multi-part process. It would be easier if I were a federal judge and just told you when you were going to do things, but you might not like it as much.
I don't know. I've lived in the federal system for so long and been told what to do by Judge Pittman and the rest of them that I'm okay with it. But I also can live with the Travis County system as well, Your Honor.
All right. I appreciate your time this afternoon and your professionalism. I think we already have some folks lining up in the waiting room for our next hearing, so I'll go ahead and excuse you. From July 2024, we're proceeding remotely as this is an emergency hearing and caused them. And if we could start off with just getting appearances.
Yes, Your Honor. Patrick Sipe, representing the petitioner.
And I'm Kathleen Brown. I'm here along with Patrick Sipe for petitioner. I'm going to mute because my dog will definitely start barking as soon as we start this proceeding.
All right. Thank you, Ms. Brown. Okay, Mr. Sipe, and you're joined by your client this afternoon?
Yes, Miss Regalado, Crishelda Regalado, here as well.
Okay. All right, and the court has received the second amended petition and the request for the ex parte TRO. But we'll go ahead and take the time to go through what has happened recently, Mr. Sipe, and the relief that you're asking for. I believe this is a request for a kickout order.
That is correct,
Okay.
Your Honor.
All right, well, I'll go ahead and give you the floor.
Absolutely. There was an attempt by my client and her daughter to move out during these proceedings just because of the situation. That being, I don't know if you had a chance to read the supporting declaration, but there is not only a history of domestic violence, but there is currently domestic violence happening, not only just to my client, but specifically to my client in front of their 11-year-old daughter. There was an instance earlier at the beginning of the year where I think she was 10 at the time, she had to actually call the police to intervene because the respondent Ricky had put a gun to my client's head. It's not a situation that a daughter should, or that a child at all should have to live with, let alone not even withstanding the fact that my client shouldn't have to be living in that situation either. They had to move back because there literally was nowhere else for them to go. Ricky Regalado he's a long haul trucker. He's got an 18-wheeler with a bed where he is actually currently sleeping now. I just learned that he's been staying there for the past week or so because every time he and my client meet in person, there's verbal arguments, including in front of the child, and the arguments escalate to physical contact. Last week, he headbutted my client in the middle of a verbal dispute that they were having. And the 11-year-old child has asked, does she need to call the police to get the two of them to stop arguing, to have him stop physically abusing Crishelda, which, again, no 11-year-old should have to be living in a situation where she is the person that intervenes while the parents are fighting. And we just feel that while this case is proceeding, it's just in the best interest for all parties. If he's ordered not to return home, he's, like I said, he is currently sleeping in his 18-wheeler, but will get drunk, show back up, go to sleep in my client's bed instead of on the couch, which is where he was previously, makes my client scared to be at home. And honestly, Your Honor, that is the situation.
Okay, understood. Okay, well, I don't think I have any questions for you. Let me just pull up the proposed TRO if I can. I think you sent it in. Yes, here it is. Let me just look through it to see if I have any questions. And have you contacted the court administrator concerning setting a hearing on temporary orders?
I believe we were waiting on the outcome of today's hearing.
Okay.
First. There is one other matter that I wanted to mention just because it has to do with Travis County standing orders. This case was originally filed back in January. There was an attempt to reconcile, which is why the parties live. I may be wrong on the date and I apologize. Sorry, there was an attempt in January to reconcile, which is why all the parties are currently living in Guadalupe County, which is currently the county where Diane is going to school. School's about to start again. I just wanted to make sure that the court was aware that, she will be going to school in Guadalupe County, not Travis County. And that's just because she's been going to school in Guadalupe County.
Yes.
There's been a lot of moving around of.
I think I understood jurisdiction attached when during a period where she had moved out and was living in Travis County with friends and family. That's when the divorce was originally filed, and since then, now everyone is back in Travis County, but I think court still has jurisdiction. There's no dispute over that.
Absolutely. I just don't want there to be an issue when the court learns that, Diane is registered for school in Guadalupe County. That's actually so that she is not having to, move schools back and forth and back and forth.
Right.
I just wanted the court to be aware.
Okay, understood. All right. I am going to go ahead and grant the requested relief, and I just need you, Mr. Sipe, if you would contact the court administrator's office and get that hearing set, because we need to include it in the order. And don't think I need anything else from you. So I appreciate you being here this afternoon, Ms. Regalado. I'm sorry to meet you under these circumstances. Wish the parties the best going forward, but the relief is the requested relief is granted.
Thank you, Your Honor, and I'll go ahead and follow up with the court.
Mr. McPherson, it's your application. So if you could just walk me through, I did read the application, but I'd like to hear a little bit more from you about what the situation is at present. So let me just swear you in if you'd raise your right hand. Okay, go ahead, sir.
Well, I've been working for the Church of Scientology for almost a year now. And I'm not even sure of his last name, but Oliver, I think that's his first name, just started coming up and causing all kinds of problems, writing chalk all out in front of our building and stuff. And I was told at one point to go ahead and go clean up the chalk. Well, he threatened me in several violent manners and told me that he was going to break every bone in my body. I'm an old man. I couldn't deal with this. So he also told me that I was going to go to jail for assault because he was standing in the way of me doing my job. So I turned around and did other things. And he was just causing all kinds of problems and has been for several months now. As a matter of fact, last Wednesday or Thursday, he started showing back up again and was harassing me as I'm walking out the door. So it's just, like I said, I'm a frail old man, and I'm not willing to deal with a young man who's bigger than I am and bulkier than I am. So that's pretty much my story.
Okay, and how do you know this individual?
I don't. That's the problem. He just started showing up and harassing people, not only myself, but other people that work here.
Okay, and I think I saw a police report. Have you?
There was
Go ahead.
police report was when he actually was getting literally up into my face when and body checked me and was like trying to intimidate me to the point where he was going to do physical harm. That's what he kept telling me. He's like, I'm gonna beat you to death. I'm gonna break every bone in your body. And I'm like, I don't know what caused any of this. I don't know why he's doing this, but he's been harassing not only myself, but like I said, other workers here at the church.
Okay, and have you spoken with anyone at the district attorney's office or the county attorney's office regarding
Well, the lawyer from LA told me that I should get a restraining order put on him. That's the only person I've actually talked to about it.
Okay. All right, well, I think the attorney appeared at the prior hearing. He's not licensed in Texas, is my understanding.
He's not, and that was the problem.
Yeah, well, his advice is doesn't go real far around here, so.
And I understand that, but that's why I went ahead and continued doing this. I mean, I was in the hospital last week, and part of this is the stress that this is putting under me, and I'm not able to really deal with this a whole lot.
Okay. And the application here, Mr. McPherson, is for a protective order, not for a TRO. You understand that?
Okay. And the difference between the two, I'm sorry to be stupid.
Well, it's my job to be the decision maker. I am not able to serve as anyone's legal counsel or to really give you advice, but I mean, I can tell you what's in front of the court is an application for a protective order. So I can rule on that. I can't take action on something that's not in front of me. But why don't you tell me in layman's terms what it is you are asking that the court do with reference to this individual, Oliver?
Actually, I wish you guys would arrest him and put him away. I know he has some previous history of domestic violence somewhere back in some other state. I think it's New Jersey or something, but I don't know why he's here. I don't know what he's doing or why he's continually harassing me specifically. And I'm just want it to stop.
Okay. And so it's your belief that he has threatened you with bodily injury?
Yes, we have a video of him actually doing just that. We have a lot of videos of him coming up, and he never attacked me, but the threatening manners with which he came across, it was like, I mean, the first time I ever dealt with him, I ended up coming back in and I was shaking like a leaf. It's because I didn't know if this younger man was going to beat me to death or not.
Okay. All right, Mr. McPherson, I don't believe that the court received a copy of any of the video that you're referring to. So I'd like to ask you if you could email that in to my staff. I would appreciate it. I'd like to take a look at that. So I do want you to understand a couple of things here. First of all, I don't have the power to arrest anyone.
Okay.
I'm a judge, not a law enforcement officer. So
Yes,
if you believe there are circumstances or if something happens and you believe an arrest needs to take place, then Austin Police Department is who you need to contact. The second thing is this is not a criminal court. So this is a civil court, and I do handle protective orders and restraining orders, but so some of what you are looking for is outside of my jurisdiction. I just want you to understand that. And you have the right, if you feel you are being threatened or if something happens down the road, to contact the police and or the district attorney's office about it.
Yes, Your Honor.
Okay. So why don't you email the video? You don't have to send me every one, but if you could send a video that depicts the threatening behavior that is outlined in your application. That would be helpful. And so the final thing I wanted you to understand is an emergency protective order is temporary.
Okay.
It does not last very long at all. All of that will be reflected in the order, but basically it's good for 20 days.
Okay.
And if you want something that lasts longer, then you have to come back you have to set a subsequent hearing and come back with evidence and ask for something for further relief. Okay. But it's only temporary. So if you could send that video in, that would be helpful. It sounds like since you're representing yourself, you probably don't have a proposed order on the protective order. So the court will need to work on that. But I do want to study the video before I make a decision. But I don't have any other questions for you. Do you have any questions for me?
Just one, I guess, and that would be, what is the difference between the protective order and the restraining order? I don't understand the difference between the two.
Okay. So one thing I will say, these kinds of questions, we have the Travis County Law Library, and there's a reference attorney that can speak with you there in a little bit more detail. But
Yes, sir.
they both, a temporary restraining order just maintains whatever the status quo is. Here, it sounds like you're unhappy with the status quo. You're wanting the court to keep this person away from you. That's a protective order. A restraining order it works a little bit differently.
Okay. I'll check into that myself then. Thank you very
Okay.
much, Your Honor.
Okay, yes, Travis County Law Library, and go ahead and send us that video. We'll take a look at it, and then you'll get a copy of the court's ruling or whatever action is taken on the case.